There are three environmental law principles that must underlie any legislation or international law on treaty on biosafety. And there are three principles. The first, the precautionary principle. The second, the polluter pays principle. And the third, the principle of sustainable development. You are familiar with the precautionary principle because that since the 1992 Earth Summit that was held in Rio de Janeiro in Brazil laid down that given the lack of scientific certainty of a certain product of science, that is no reason if we don't have enough trials done or even enough assessments done within laboratory conditions or in open field trials, for instance, for GMOs, given that there is lack of scientific certainty on their safety, is no reason to take a precautionary approach when using these LMOs or GMOs. The second is the polluter pays principle. That means the operator or the developer of GMOs must be responsible and must pay costs in case there is any damage to biodiversity or to human health apart from ecological health that might occur. The third principle of sustainable development, which is currently emerging in international law, requires that any use of science and technology must be done so responsibly that it doesn't jeopardize the use of biological resources by generations that are yet to come. That means the pace as well as the quality of development and the model of development that we choose should not put at risk and the possibilities of development for future. And that is also linked with the issue of intergenerational justice. So apart from the principles, let's now zoom right into the international law on biosafety, which is developed under a multilateral environmental agreement, which is the Convention on Biological Diversity. CBD, as we know it, came into force in 1993. And so the issue of biosafety is as old as that and perhaps older, when the technology actually developed in the 70s and the 80s, much before the international law could keep pace with that. But 10 years after the CBD came into force, a specific protocol, which is a daughter treaty or a sub-treaty to the CBD, which is called the Cartagena Protocol on Biosafety, came into force in 2003. Now this protocol is what is the international law on biosafety. It attempts to strike a balance between trade interests in biotechnology as well as the protection of biological diversity. And within the Cartagena Protocol on biosafety, there is a very specific provision which asks for liability and redress provisions to be addressed. And it was only in 2010 that a further supplementary protocol on liability and redress, called the Nagoya Kuala Lumpur Protocol on Liability and Redress, protocol called the Supplementary Protocol, it has been developed, and this is to deal with issues of liability between countries when LMOs are either transported across borders and used for food, feed and processing. And it also provides, apart from the liability provisions, also provides for redress, which means if it is established on evidence that there has been damage to biological diversity or to human health because of that particular LMO transported from another country, then the sender or the operator, and there are definitions given within the text of this supplementary protocol which defines who will be made liable. In that case, when it is established that damage has occurred, then the whole machinery of the supplementary protocol then focuses on trying to get redress and for the polluter to pay. So this is premised on the principle of polluter pays. Now, apart from the specific legislation that are developing in different countries, on the issue of biosafety. We'll also look at some of the regulation, because not all countries have made full legislation that have gone through the parliament, but have made executive rules to deal with the issue of biosafety. And even though the proponents of LMOs and GMOs would like us to believe that GMOs and their application has become the norm worldwide, this is hardly true, because in about 245 countries that we have in the world today, just about 29 or 30 countries have begun to use LMOs or GMOs in different sectors. So in India, what does the biosafety regime look like? We are in a state of transition between the existing regulation, which are executive rules called the Genetically Engineered Rules of 1989, which have been issued under the Umbrella Environment Protection Act of 1986. And it is the Environment Ministry which is the nodal governmental agency at the central level to deal with the issue of biosafety. Yet there is much discussion on a legislative initiative, because we have a draft Biotechnology Regulatory Authority of India bill, which is supposed to be tagged with the Ministry of Science. And the questions that are being asked by civil society quite legitimately is, if we are in the process of developing an independent regulatory authority on biotechnology, then this should not be in any way seen close to the Ministry of Science and Technology, which is the nodal governmental agency at the central level to promote this technology. Otherwise, this would be typically a case of conflict of interests. But there is a timeline, even though there is this discussion on developing a full-fledged biosafety legislation is ongoing. There is a specific timeline for national law to be developed, and this timeline has been prescribed by the international law contained in the Cartagena Protocol, which says that member countries of the Cartagena Protocol, and there are 160 countries today that are a member of this protocol, all the countries that are members are required to set up legal and administrative frameworks by the year 2020. It's important to note here that the United States of America, biggest promoter and developer of modern biotechnology, is not a member of the Cartagena Protocol and therefore does not subscribe to the law on biosafety as it is developed internationally. This is important to keep in mind, because when we get into the national landscapes and see what are the challenges for regulatory bodies, we also have to place it within the political economy and understand the kind of players that are behind the biosafety regulation.